Good evening. My name is Erica Cordell, and I have had the pleasure of taking this Health Services Management Human Resources class. I have learned an abundance of knowledge and have also been able to identify and implement certain ideals in the current workplace where I currently work. One aspect of human resources that I found very interesting is the government statutes within the employment environment that are upheld for the protection of both employer and employee. I took interest in this topic because among the different places that I've worked, I've noticed that some healthcare practices are more observant in these laws than others. And what I mean by this is that some managers make it more of an effort to make these practices more acknowledgeable. Within an environment of a workplace, there are six main statutes that have been implemented by the government that need to be upheld to protect the rights of both employer and employee, as I stated. These six statutes are known as the Civil Rights Act, the Age Discrimination in Employment Act, the Fair Labor Standards Act, our all well-known HIPAA, and the Americans with Disabilities Act, and also the Family and Medical Leave Act of 1993. Now, of the most important I find is the Civil Rights Act. It's important because it prohibits employers from discriminating on the basis of race, color, religion, gender, and national origin. This statute also encompasses prohibiting discrimination in such areas as voting, public accommodations, use of public facilities, public education, and employment. This act became one that was very strong under enforcement, particularly after the 1991 amendments, when punitive damages began to be awarded when the intentional or reckless discrimination was proven under law. Such damages that were awarded may include things as emotional pain, suffering, and also loss of wages. The next act I want to discuss is the Age Discrimination in Employment Act of 1967. This act forbids discrimination against men and women over the age of 40 years old by employers, unions, employment agencies, state and local governments, as well as the federal government. The U.S. Supreme has ruled that employees may sue employers or organizations based on disparate impact theory of intentional discrimination due to a person's age. This means that if you're over 40 years old, you cannot withstand discrimination from an employer just based on your age if you're unable to perform a certain act of duty, not based on your age. The next act I want to discuss is the Fair Labor Standards Act, also known as FSLA, which concerns the minimum wage, overtime payments, child labor, and equal pay of employees. This act forbids several things such as the employment of children under the age of 18 in hazardous occupations, and also it places restrictions on children under the age of 16, such as restrictions to include how many hours they're able to work and what times of day they work during school hours. The next act, which is one of the most important acts that we face in the healthcare field, is the HIPAA law. HIPAA went into effect on April 14, 2003, and is very critical in all areas of the healthcare field. The privacy rules of HIPAA were regulated to protect personal health information that's electronically transmitted or maintained by health plans, healthcare clearinghouses, and healthcare providers. Now, this act has become so important, especially in today's society, because most healthcare systems that we know today are on electronic medical records. Being that it's an electronic medical record system, it's much easier to access over the World Wide Web. Everybody knows the World Wide Web can be hacked into at any time by any professional. Also, it maintains the privacy of your personal records when it comes to employees, family members who are not able to access your information, as well as unwanted members or outside parties such as other doctors who you may wish not to access your information. Even though they do have access, because of your HIPAA laws, only with your consent can they get access to your information. Another important act was the Americans with Disabilities Act, also known as the ADA, which prohibits discrimination against people with disabilities in employment, transportation, public accommodation, communications, and governmental activities. The ADA establishes requirements for telecommunication relay services within an employment environment due to the fact that they may also have access and ability to perform their responsible duties, accommodating physical or mental limitations of an employee. It does not require an organization to hire someone who has a disability. No discrimination must be displayed to a person with such disabilities in the workplace. If a person with such disabilities is unable to perform their job duties, then yes, it is okay for them to be acknowledged or fired or reprimanded on their duties. But just for the simple fact that they do have a disability does not mean that they cannot obtain a personal job. The Equal Pay Act of 1963 is another very important act, which requires employees to pay all employees equally for equal work, regardless of their gender, male or female. And this is very important in today's society because we as women in the workplace demand equal pay, such as men. Now, the intent of the act was to correct wage disparities experienced by women workers because of sex discrimination, which we as women dealt for many, many, many years. But today, in this day and age, 2013, we do strive for equal pay for equal work. This act outlaws once prevalent practice of paying women less based on their gender and not their job performance. Now, with all 6 of these statutes, me personally as a manager, I would make sure that I was personally knowledgeable on all employment laws, limitations, and acts, both previous and new. If I am fully informed, then I am able to fully inform my staff as well as other administrative people of these acts to make sure that these limitations, these regulations, these laws are upheld responsibly, properly, and accurately within the workplace. Upon hire, I would have a segment of training that would have all employees review these statutes and also sign off as read and understood. This way, there would be no reason, if any of these acts were violated, that an employee would be able to tell me, well, I did not understand or I did not comprehend that that was a law. Because they had signed off and they had read and understand these laws, that would no longer be an excuse. I would also have documentation on hand in the employee workbook just for easy access, as well as on the health site's intranet. With the intranet, I'll be able to make sure everything is accessible. That way, if anybody needs to refresh their memory on these laws and these acts, or have any questions about these laws and regulations, they'll have easy access if needed by myself or any other employee. These acts are very important in the healthcare place, and again, as I said, I took a particular interest in this segment of our class because I find it interesting that even though these are particular laws that are supposed to be met, these laws are not really enforced the way they should be. This has been an exceptional class and I've been to be a part of. And this is Eric Cordell saying thank you for this experience and have a great holiday. I just want to also state that to credit my resources in this documentation, I would credit our textbook, Human Resources in Healthcare by Fried and Fowler. Thank you very much and have a great day.